Chapter 7. Classification and Forms of Common Law Actions. Sec. 33. Brief General Account of Common Law Actions. A brief general account of common law actions will be helpful before taking up the consideration of each one. There has been some speculation regarding their origin, it being contended that they were contrived to give the entire administration of justice to the patrician order of Rome to the exclusion of the great body of people. See again, it is said that they received their peculiar forms at a period when a scholastic pedantry had overrun and perplexed with its arbitrary rules every branch of science. Actions at law were derived from the original writs, it being impossible to institute an action without first having an original writ issued authorizing the action. And if there was no original writ, there could be no remedy. An original writ was a mandatory letter issuing out of the Court of Chancery, under the Great Seal, and, in the King's name, directed to the sheriff of the county where the injury is alleged to have been committed, containing a summary statement of the cause of action, requiring the sheriff, either to command the defendant to satisfy the claim or, failing to do so, then to summon him to appear in one of the superior courts of common law, to account for his non-compliance. In some cases it merely required the sheriff to enforce the appearance. No action could be maintained in any superior court without the sanction of the king's original writ, the effect of which was to give cognizance of the cause to the court in which it directs the defendant to appear. Some of the writs were of remote and undefined antiquity, while others are of later origin, the history of which is easily traced. This part of the common law judicial system was not only connected with the whole scheme of actions, but had an important bearing in pleading as well. The circumstances surrounding the existence of this practice was a peculiarity of the national law of England, and the fact that this form of practice was unknown to the practice of other countries naturally excites curiosity as to its origin. Some of the writs are traceable to the reign of Henry II, 1154, being found in the work of Glanville. But search for any distinct and satisfactory account of their original invention would be in vain. The language of the writs is supposed, by some authority, to have owed much to the Roman forms, while other antiquarians declare that they have the most remote English extraction, having hardly a word derived from the Caesarean law. Stephen states that one of the earliest refinements in forensic science was that of classifying the various subjects of litigation, and allotting to each class an appropriate formula of complaint or claim, a method devised in a view to the more certain definition of the nature of those injuries for which the law affords redress, and perhaps, also, to save the trouble of inventing new modes of expression for each particular case or wrong, as it might arise. Whatever the object, it is certain that such was the practice of ancient Rome, and so severely were these formulae observed that any deviation from them was fatal to the cause. Certain it is the English method or contrivance of fixed judicial formulae bears strong resemblance to the Roman methods. It is equally certain that our English ancestors followed the example of the Romans and adopted such a subtle form of procedure that the most trifling mistake resulted fatally to a suitor. In the language of a writer, and just as the Romans as they advanced in civilization replaced the solemn and unyielding legis actionis, actions at law, by a more flexible formulary system, so English law passed under the dominion of a system of writs which issued from the royal chancery. This system grew up little by little. Its period of most rapid growth was from the accession to the throne of Henry II. In 1154 to the death of his grandson, Henry III. In 1272, the actions in the earlier history of the common law were more numerous. As society progressed, as commerce extended, as the relations and business of life multiplied, the necessity for speedier and better justice increased, and the number of actions decreased. Sec. 34. Classification of actions. The earliest division of actions was into real, personal, and mixed, which classification is preserved to the present day. The real actions were based upon the plaintiff's right of property in the specific thing which was the subject of controversy. They were brought to establish their ownership, and sometimes his right of possession against an adverse claimant who had taken possession and asserted ownership. In this respect they were copied from the Roman actions. Mixed actions were those mostly employed for the partition of lands among co-owners. Others were subsequently invented. The most important was that of ejectment, which always preserved the form of a mere possessory proceeding, although it finally took the place of the petitory real actions as the means of trying titles. Personal actions are those brought for the recovery of debt, or of damages for the breach of a contract, or of specific recovery of personal property. Originally, there were a number of real actions. The nature of these actions depended of course upon the peculiar state of the law as to real property. What a real action was originally concerned with was only the question of right or title to a freehold estate. The mere seizure or possession, as distinct from the right, was something which the law did not take under its protection, and for the deprivation of which it provided no remedy. The first division of real actions was into 1. Writs of right, and 2. Writs in the nature of writs of right. The first were divided into 8 forms of action, while the latter was divided into 14. Writs of right were actions which pertained to the possession and the right. These forms of action continued until about 1154. These actions passed through several stages of development, resulting in the action of ejectment, about which more will be said when that action is considered separately. The older classification of common law actions was called formed actions. They were so designated because they were formed by the authority of common law precedent, and mark the era before the actions were changed by means of statute, and include those actions in existence before the Act of Westminster II, under which case assumpsit and triva were formulated. The formed actions were entirely inadequate, as was shown when discussing the subject of the history of equity, and this was due to the crude notion of a contract then prevailing. The formed actions of debt, detinue, and covenant existed before the idea of contract, as we are familiar with it, was conceived. Classification of actions: 1. Real. 2. Personal. 3. Mixed. 1. Real actions: 1. Writ of right. 2. Writ of forbidden. 3. Writ of dower. 4. Writ of quare impedit. 5. Writ of right of dower. 6. Ejectment was finally classed as a real action, although it is also mixed. 2. Personal actions, subdivided into 1. Ex contractu, those based upon a contract express or implied, which are 1. Assumpsit. 2. Covenant. 3. Debt. 4. Account. Does not occur in the late common law. 2. Actions ex delicto, those brought for tort, or wrongs not based upon contract, and embrace 1. Trespass. 2. Triva. 3. Case. 4. Detinue. 5. Ripline. 3. Mixed actions, those which pertain to both classes, under which comes 1. Ejectment. Stephen considers that this action should be ranked as a personal, rather than a mixed action. But the statute relative to writs of error, and the Uniformity of Process Act seems to imply that ejectment is not a personal, but a mixed action. Sec. 35. Real actions. Special mention may be made of real actions and their development. A real action is one brought to recover the freehold in lands, tenements, or hereditaments, claimed either in fee simple, fee tail, or for life, by one who is divorced, against him who is tenant thereof. This action existed only in favor of an owner of at least a freehold. They did not extend to a right of possession less than for life. The ancient real actions were classified according to the nature of the thing recovered. In one class land or incorporeal hereditaments were recovered, in another class, in addition to lands and incorporeal hereditaments, damages as incident thereto were also recovered. Again, these actions were classified according to the kind of title held by the complainant. One may have a proprietary or a possessory right. A distinctly possessory action was not a native Anglo-Saxon but originated in Roman law. A complete title must be accompanied by the right of property, right of possession and actual present possession. A person in possession had a right or species of property, irrespective of the means by which he acquired it, and so the law affords mere possessory remedies. The ancient real actions would have been more readily understood, if the technical distinction between proprietary and possessory actions had never existed. And this distinction was in due time abolished, all the ancient, real and mixed actions being abolished, excepting ejectment, quare impedit and 2 writs of dower. The ancient real actions are extensively treated in Martin's Civil Procedure, Sec. 117 to 164, inclusive. All real actions were at first included in the following: writs of right, strictly so called, and writs in the nature of writs of right. Writs of right were concerned not merely with possession but with right. There were 14 writs in the nature of writs of right covering a large remedial field. Sec. 36. Modern real actions. The modern common law real actions were ejectment, trespass to try title, writs of entry and disseisin, dower and partition, forcible entry and detainer. Of ejectment nothing will now be said. Trespass to try title was derived from trespass square clausum fregit, bare possession being sufficient to support the action as against a mere wrongdoer, recovery resulting only in damages. If the entry constituting the trespass amounted to an ouster of the complaint, he was entitled to a writ of habeas facis possessionum. This form of action was adopted in some of our states, and still remains the exclusive form of action in one state for the trial of controverted titles. 59. Writs of entry and disseisin, one of the ancient possessory actions, was adopted in a considerably modified form in a number of states. 60. Writs of dower was a common law action, though in this country it has generally been made a statutory proceeding. In England courts of chancery assumed jurisdiction over writs of dower, and, the remedy being much more effective in the hands of this court, it was consequently here more extensively pursued than in the common law courts. Partition, or the writ in the action for partition, was abolished with the other real actions by Act of Parliament in the reign of William IV. Courts of Chancery had previously exercised jurisdiction over this remedy concurrently with common law courts, and it continued to do so. Forcible entry and detainer was a summary remedy to restitute premises by the justices of the peace or by the King's Bench after a verdict of a jury, and was recognized as a civil action. According to common law doctrines, anyone who had the right to enter could do so by the use of overpowering force. This was modified by statute providing that entry could only be made in a peaceable manner. The statutes furnished summary remedy against the wrong of forcibly entering upon the peaceable possession of another. Sec. 37. The formed actions, the Statute of Westminster 2. What are termed formed actions were those existing prior to the Statute of Westminster 2. They are debt, detinue, covenant, account, sire faces. These remedies were entirely inadequate for the redress of rights according to the advance of civilization. In the progress of society cases of injury arose new in their circumstances, which could not be remedied by any of the writs then known in practice. The clerks in Chancery, whose duty it was to prepare the original writ, were without authority to devise new forms to meet the exigency of such new cases, or their authority was doubtful, or they were remiss in its exercise. Consequently the Statute of Westminster 2, 13, Edward I. 1285, Chapter 24, was enacted, which provided, that as often as it shall happen in the Chancery that in one case a writ is found, and in a like case, in consimile casu, falling under the same right, and requiring like remedy, no writ is to be found, the clerks in Chancery shall agree in making a writ, or adjourn the complaint till the next Parliament, and write the cases in which they cannot agree, and refer them to the next Parliament, and by consent of men learned in the law, a writ shall be made, lest it might happen after that the court should long time fail to minister justice unto complainants. This statute passed A.D. 1285. Stephen, in discussing this statute, expresses the opinion that it does not give or recognize any right to frame writs for cases entirely new, and that for cases of that description no writ could lawfully be issued except by authority of Parliament. But new writs were produced, according to the principle sanctioned by the Act, in consimile casu or upon analogy to actions previously existing. Only 3 new writs were framed under the authority of this statute, writs of case, trava and assumpsit. It has been frequently claimed that a liberal construction of this statute would have avoided the need for the Chancellor's extraordinary jurisdiction. While the language of the statute permitted new writs in cases falling under like law and requiring like remedy, with existing ones, it is said that the courts gave it a highly restrictive meaning, adhering to the letter and ignoring the spirit. The common law judges assumed for themselves the same exclusive jurisdiction to pass upon the propriety and validity of the new writs which they had exercised over those issued by the clerks prior to the statute. They did not regard the action of the Chancery officials in sanctioning a writ which would give a new remedial right to the plaintiff as at all binding, and in fact rejected all new writs contrived in pursuance of the statute, which did not closely conform to some one of the existing precedents. In Massachusetts in 1807 it was held that the Statute of Westminster II operated as part of the common law of that state to the extent of making new writs grantable, holding that when the remedy to which a complainant is entitled cannot be obtained by any writ conforming, in its outlines, to those prescribed by the statute, it was the ancient and constant practice of the court to grant him a writ whereby he may obtain his remedy. This statute was not broad enough in its provisions to have authorized such remedies as were afterwards pursued in equity. A careful scrutiny of the three new actions created by the authority of this act will show what a labored effort was made to have the new actions conform, by analogy, to some one of the existing actions. And, as current equity jurisprudence has well stated, without revolutionizing their entire procedure, and extending their jurisdiction, they could not have afforded the relief that equity ultimately gave. But, if Englishmen had been disposed to have done so, they could have so modified their whole system that it would have been unnecessary to have created the new and independent system of equity. Sec. 38. Some disadvantages or evils in the common law actions. The evils in the old actions were many. If a plaintiff brought the wrong action, he had to go out of court, pay the costs and begin a new one. There was one right action and 8 or 9 wrong ones. It was difficult sometimes to determine the right action. The cases were numerous where parties were turned out of court for mistakes. This difficulty may be illustrated by the wrongs remedied by the actions of trespass and case. There was a great deal of formality, falsehood and fiction in some of the actions in the statement and the pleadings. Each had its own form of declaration, which differed from every other in the commencement, in the conclusion, and in the allegations throughout. There was in some of them so much of fiction, form and falsehood that it was impossible to make a plain and simple statement. Introver it must be stated that the plaintiff lost the property, and that it came into the possession of the defendant by finding, though neither statement be true. Inter espes it had to be stated that the injury was committed with force and arms when nothing of the kind occurred. The basic theory of the common law system was form rather than substance. The maxim ubigius, iberum idemur became a mockery. Procedural law, in England as in Roman jurisprudence, retarded the growth of substantive law. Ceremonies had been embalmed as primary and immutable principles of law. Forms and modes of procedure stood in the place of substantive rights, nor could justice see beyond them or above them.